Trial, judgment, and post-trial motions. Right to a jury trial. Seventh Amendment provides that the right to a jury trial in civil actions at law, but not equally, so not where equitable relief is sought. Demand for a jury trial may be included in any pleading. The deadline must be made within 14 days of service of the last pleading, raising a trialable issue, otherwise waived. Number of jurors, minimum of 6 jurors, maximum of 12. Verdict, unless the parties stipulate otherwise, the verdict must be returned by at least 6 members and be unanimous. Cases involving law and equity claims. Jury will decide underlying facts on claims at law first. Equity claims left for the judge to decide. Jury selection process. Each party may strike jurors either for cause or through peremptory challenges. For cause strikes are used to strike potential jurors for cause. Bias, prejudice, relation to the party. Each side has unlimited for cause strikes. Peremptory strikes or challenges. Each side has 3, which can be used for any race-neutral and gender-neutral purpose. Non-jury trial. This is parties can elect for a trial on documentary evidence alone and for a non-jury bench trial. Judge must make a fact finding and state separate conclusions of law. Jury instructions and verdicts. Jury instructions. Parties may file requested jury instructions to be given to the jury during deliberations, usually given to a jury at close of evidence. Proposed instructions. Court gives parties its proposed jury instructions before final arguments. Objections. Parties must have an opportunity to object before final arguments and before instructions are given to the jury. Failure to object waives the issue for appeal. So jury verdicts. Court decides a verdict to be used. General verdicts. Jury finds plaintiff for defendant and decides amount of damages or relief due. Special verdicts. Jury asks to make factual findings. Court applies the law to those facts, and the court submits questions to the jury regarding each ultimate fact and legal conclusion based on jury findings. Parties must object to proposed jury questions before jury deliberates. General verdict with interrogatories. Court can require general verdict and ask jury to answer specific questions concerning ultimate facts. Purpose is to ensure jury properly considered important issues. Judgment as a matter of law. In extraordinary circumstances, a judge can take a case from the jury and render a decision on an issue. Can occur during JMOL or after jury verdict in the RJMOL. Court views evidence in light most favorable to non-moving party. So judgment as a matter of law, also known as a directed verdict, is a motion brought by either party before a case submitted to jury. Defendant can bring a motion upon close of plaintiff's evidence or all evidence, and plaintiff can file at close of all evidence. So the standard is that courts can grant a judgment as a matter of law on an issue if a reasonable jury would not have sufficient evidentiary basis to disagree as to the result. Reasonable people could not disagree. Renew motion for a judgment as a matter of law. After court enters judgment based on a jury verdict, losing party can file a renewed motion for judgment as a matter of law, for entry of judgment in his favor, must be filed within 28 days after entry of judgment, can only be filed if the judgment as a matter of law was originally filed. The standard is the same standard as for the judgment as a matter of law. Court can grant the judgment, the renewed judgment for the matter of law if there is insufficient evidence for a reasonable jury to have reached the verdict. Note, occasionally referred to as judgment notwithstanding the verdict, or JMOL. Motion for a new trial. Either party may file a motion for a new trial if judgment was entered but serious errors occurred at trial. Must be filed within 28 days after entry of judgment. Grounds for new trial. Unlimited but potential errors include prejudicial error, serious error that makes judgment unfair, judgment mistakes law, gives wrong jury instructions, prejudicial misconduct of a party, attorney, jury, etc. Jury considers evidence excluded at trial. Judgment against weight of evidence, jury erred in reaching verdict given the evidence before it. Newly discovered evidence, excessive or inadequate damages. A court cannot increase jury award. Judge can order a new trial or offer remittitor if convinced the award is too high. A remittitor, if jury awards an amount that is too high, it shocks the conscience. Court can order a new trial or offer plaintiff a choice of taking a lesser figure set by the court. Motion for new trial versus judgment as a matter of law, or renewed motion for judgment of a matter of law. In granting a new trial, court is not directing judgment, but rather saying the process should restart. There was some error necessitating a do-over. Motion to set aside a judgment or order. A court may relieve a party from judgment or a court order if any of the following arise. 1. Mistake, inadvertence, or excusable neglect. For example, relief from a default judgment that entered against defendant who did not receive actual notice. 2. New evidence undiscoverable at the time of trial. Evidence existed at the time of trial and moving party made diligent efforts to discover it. Evidence would likely have changed the result. 3. Fraud, misrepresentation, or misconduct by opposing party. The fraud must be established by clear and convincing evidence and must have prevented the party from fully and fairly presenting her case. 4. Judgment is void. Relief from judgment rendered by court that lacks subject matter jurisdiction. A judgment is not void merely because it is erroneous. 5. Judgment has been satisfied or discharged. This includes judgments based on an earlier judgment that was later reversed or vacated. 6. Any other reason that justifies relief. This is a catch-all used in extraordinary circumstances. Note, for issues 1 through 3, motion may be brought any reasonable time within a year of entry of judgment. For issues 4 and 6, motion must be brought within a reasonable time.